Welcome to Lawyer on the Line.
Welcome to Lawyer on the Line podcast number 2. I'm Roger Riedmiller, and I have been practicing law in the state of Kansas for 39 years, handling work comp, personal injury, automobile accident, and trucking accident claims. I started doing more truck-involved collisions because they ended up being both work comp and truck collision cases. And that's kind of our niche here at Riedmiller, Anderson, and Scott. And so we handle a fair number of cases where the injured individual is both a workers' compensation claimant and a accident or collision victim in a truck claim. So there are two separate cases going side by side. And as a result of that, I often get my partner here, Mark Scott, involved in helping me with those claims.
I'm Mark Scott, one of Roger's partners. Been practicing for 33 years at this point. And for the last 15 years or so, I've been doing more and more truck litigation with the firm. Initially, these cases were kind of looked at by a lot of attorneys as just a car crash, no different. But the more I studied, the more I saw that there were a lot of regulations that come into play, and that a truck crash is very different than a car crash. And when we talk about these cases, one of the very interesting things we hear is how people often call these accidents. And
well, I just did too.
I know you
I
did.
started out, it called it an accident, and I'm thinking, well, but that's vernacular, right?
It is vernacular.
The way people talk.
But the way I look at it, an accident is something that usually should be faultless, just something that happened. But a collision is something that may have happened because of many different factors.
But let's dig right into it. How does, in a typical automobile collision case, how does fault get dug into, discovered, and brought to light?
Sure. In a car crash, one that's just car versus car, what we're generally faced with is a motor vehicle collision report. Sometimes we'll get statements from that an insurance company has taken of people, and we can take our own. But the information that we have about the crash usually is pretty limited. The report will have a narrative in there where hopefully the trooper or officer will detail out the physical scene and that type of information, so we can start doing a more in-depth investigation in it. But in a commercial motor vehicle crash, the investigation oftentimes is much more in-depth.
Well, and having worked on these cases with you and Don, a number of these cases, I see the number of letters that go out in the very beginning of the typical truck collision case includes the preservation of evidence letter. It includes the letter to the Kansas Highway Patrol, who's usually the one that's going to investigate, not always. And they have a separate division that does a KDOT investigation. We send a letter out for that. We send a letter out to the trucker, but also the trucker's possible employer, owner of the truck. The business is on the back of the trailer,
Right.
and so all of these things are intended to try to start gathering or preserving the evidence. Is that correct?
That's correct. We're just trying to get all information preserved, because it's surprising how often that a crash isn't an accident. There were failures along the way that led to this crash happening, and only through gathering and preserving that information are we able to find those failures and then use those, because each failure has a lot of meaning in this type of a case.
So when we're talking about fault, we're not just talking about the driver, he was going too fast, he or she was going too fast, or the driver's was oversteering or overcorrected. We're talking about more fault than that. Is that right?
It is. It can go back to um, the time of hire of this driver. Was the driver a qualified driver? Did the company follow all the regulations, doing a background check? Not necessarily having to do a drug test, but sometimes you do have to have that right at the get-go. But did they contact the prior employers of the driver? That information is required to be kept by prior employers for numerous years, because what we want to have are safe, qualified drivers. The only way to have that is to have a paper trail to see what that person's background was.
So you're talking about the fault of the company there, right?
Yes, that can be a company problem. If they hired a driver that they wouldn't had they done a proper investigation. You find a driver that has 4 DUIs in the past, pretty good indication that you need to really look at that driver, make sure that behavior's been corrected, and that they are qualified and a fit person to be the driver.
What do you do to investigate, or what's the nature of the investigation with respect to the fault of the equipment and how that led to the accident?
Sure. Maintenance religious, excuse me. We would look at for maintenance records. Part of the investigation by the trooper or a deputy, it sometimes is a review inspection of the vehicle. So they're looking for things like, are the brakes properly adjusted? Are there any problems with any of the suspension components of the vehicle, the steering components? If those things are flagged, they should be fixed by the company. If they're flagged and they're not, then there is another avenue of responsibility. And all these little violations can add up to the crash happening.
Well, and then you also have the maintenance, inspection, and equipment records. Is that correct?
Yes.
And what do you do to try to gather those?
Well, part of the reason for that preservation letter is to get that information retained by the trucking company. So if and when a lawsuit is filed, that information is available and can be discovered.
Why doesn't the company or driver or responsible individual have with the company have, like HR, I don't know who it would be. Why wouldn't they have a legal responsibility after an accident to gather these records and preserve them?
And they do have, but there's time frames on how long that information has to be kept. And with the preservation letter, we're highlighting not only the things that maybe the regulations say have to be retained, but other important things. It can be very important to look at credit card slips. Do those credit card slips match stops to fill up the truck with fuel? If not, then we got a problem. If there's records, or if there's no records for say 5 hours, is that an indication that the driver drove straight and didn't have any brakes that are required?
Well, okay, I get that, but what if they just don't have the records? They're gone. They disposed of them when 6 months or a year down the road, you get involved in the claim and they say, well, we don't or hadn't or don't keep those particular records. I had a case once where I actually got the judge to infer fault, or it basically allowed me to argue in front of a jury that because that record was not kept and that record would have been helpful in determining the facts of this particular issue in the case. I think it was brakes or braking mechanism. The judge inferred that that would have been a bad record.
Sure. And so what Roger's speaking about is what we call spoliation of evidence. So if you have gotten your letter of preservation out timely and you gave that company notice that information is important to be kept, and then they do not keep it, there can be an instruction given by the judge to the jury about spoliation of evidence, that there was a need for that, they had notice of keeping that information, and because they didn't, they spoiled that evidence, that can be held against them. So it can be very helpful when you're going to a trial in one of these cases.
Now, I've heard you talk about trying to create a pattern of information, a pattern that shows what the nature of the conduct is by the companies in the way they handle truck collisions and the way they handle their drivers and their trucks.
Right.
What are we talking about as far as pattern goes?
Well, I'm not sure exactly what you're meaning, but if we find a pattern of not doing a proper qualification check of drivers, that can show that the company is really not focused on being safe. They're just focusing on getting drivers on the road as quick as possible to make the almighty dollar. And we do see that sometimes, unfortunately.
Well, I'm sorry.
The pattern can just be seen by lack of maintenance of the vehicle, shoddy hiring, things like that.
But had you ever seen a truck collision where there's only one area where the employer is at fault? In other words, bad brakes and everything else is perfect?
Oftentimes the brakes are the issue because the driver can do an adjustment of those brakes themselves when they're doing their pre-trip inspection. It's part of what they're supposed to be checking. And so there's slackers is what they call them on these brakes that can be adjusted right then by the driver and to make that brake system work effectively. Not sure if that answers your question.
Well, the cases that I have been involved in usually involves the truck driver having borne some of the fault in contributing to the accident, the way they drove the vehicle. And then when we start looking at the maintenance on the vehicle isn't well maintained, right? Then we look at the background of the trucker, and the background of the trucker is either they weren't trained very well or they have a history of a lot of accidents. Um, isn't that what we're really looking for, is if there's a pattern of misconduct, negligence, not just with the driver, the way they drove the vehicle, but with the way the vehicle was maintained, and the way the employer acted prior to the collision in training, preparing the truck, preparing the load on the truck.
Yes. Yeah. And all those things, I think, make up why this crash is not an accident. It's just these culmination of all these violations, all these the spotty maintenance or not hiring an employee right, that when you wrap it all together, proves why it's a crash, and maybe even choice by the employer that caused this to happen.
But it's also, if you find that pattern, don't you start looking at things like brokerage liability?
You can look at those type of issues. You can sometimes look at the shipper. Sometimes you can look at who owns the trailer if it's not a company trailer. And so, yeah, there's those things where you can look for some responsibility. The broker situation is actually before the United States Supreme Court right now, and that is the very question: can brokers be responsible if they negligently hire motor carriers? And so, yeah, there's so many different components that are involved.
Brokers are the folks or the companies that arrange for the product to be shipped by a particular company
Yes,
to a particular location.
correct.
And so they're kind of the in-between people.
They're an in-between. They oftentimes have relationships with the different motor carriers that can become very important when you're looking at this type of a matter. But yeah, broker responsibility is a very interesting area that is still a developing part of the United States law.
So fault then isn't just a simple he rear-ended me.
Very much so.
Correct?
Yeah, very true.
And when we're talking about a collision with a truck, we're talking about a collision with an entity, a company, that could include a question of subcontractors, could include a question of who owns the trailer, could include a question of who has the obligation or right to control the trailer, I believe they call it, right? Now, the trailer is where everything sits in the transportation,
Right.
and the cab is the part that's usually the employer of the truck driver.
Yeah, usually, but we are seeing lots of companies that like to hire owner-operators, and that's done for limiting liability reasons. They think that if they make somebody an employee, they're going to have more responsibility. That doesn't really play out with the Federal Motor Carrier Safety Administration regulations. The distinction between an owner and operator, whether they're an employee or independent contractor, really doesn't mean as much as some people think, but it's still a factor to be aware of.
All right. When you're looking at fault with a truck company, then we've lined up how many different possible defendants?
So easily 4 or 5. And in Kansas, we have the ability to actually bring in the insurance company sometimes. In a normal car crash, we don't get to talk about insurance. The jury never knows about insurance. But in Kansas, we actually have a statute that allows for what we call a direct action against the insurance company. And we generally want the insurance company or the trucking company involved in the litigation. We want them to be fully knowledgeable that the case is being worked up properly, because they need to be seeing what's happening so they can kind of determine, well, are these attorneys that know what they're doing and we need to try to resolve this case, or well, these people don't know anything what they're doing. We can just take advantage of them. So yeah, pretty important.
In truck litigation, is there ever a time where the individual who is the victim of the negligent claim by the truck or truck company should not at least consult with an attorney?
Oh, I can't think of any reason or any case where they shouldn't consult. Very important to become knowledgeable about your claim and what's all involved, because I don't think the general person understands all the regulations and how they play into these pretty difficult cases.
And based upon what we've discussed here today, the complexity of fault is what really one of the main things that leads to a person needing to at least consult, if not hire a lawyer.
Yes, because even looking at a crash report in their photograph, sometimes it's very difficult to understand how a crash happened. And in those type of situations, it can really help to have a law firm involved.
All right. Well, we're just about out of time. Thank you, Mark. I appreciate that very good insight. If you are the victim of a truck collision, be sure to understand that while these cases are complex, the assistance of a lawyer, or at least a conversation with one, is almost imperative. It really, really is something you ought to do. Sit down with someone who knows, who has handled these claims, and get a fair and in English conversation with them about what you should or shouldn't do. Thanks again, and we will see you next time.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.